Welcome to Sable International's webinar on British citizenship and links to the US. Before we get started, I will do a little bit of housekeeping. For those of you in attendance, there is some icons on the top right-hand side of your screen where you can use the toggle for the screen to make it full screen or smaller. There's also a chat and a poll option, which is on the right-hand side. What I'll do is if you can go through the poll, we'll make the results available at the end. After the presentation by Michelle, we will host a live Q&A where we will field some of your questions and see if you are eligible for British citizen. What I have done is in the chat section, I have put a question format for you. If you can please provide us with the full information that I've asked there and hit enter only once you've provided all the text. So all the information comes through in one go, and Michelle can then answer those questions for you. All right, so just a little bit about Sable International. We have offices in Cape Town, Melbourne, London, and Lisbon. Some of the core services that we have apart from British citizenship is tax, wealth management, foreign exchange, study abroad, which are for students wanting to look to study in Australia, the US, and in Europe. We also have business immigration services where individuals would like to set up a business inside the UK and go through that route. And we also have accounting services for those individuals that do have businesses set up inside the UK as well. So just tonight, the presenters, Michelle Patel. Michelle will be covering off on the British nationality slides. And then myself, John, I will go through the immigration slides with you. And at the end, we will both go through a Q&A and answer any of the questions that you do have. So without further ado, I'm going to hand you over to Michelle, where he can go through the UK nationality slides.
Thank you guys for joining us. Thanks, John. I will run through each one of the slides quite swiftly so we can get to the Q&A, because I'm sure our listeners are waiting to ask their questions. If I am going too fast, don't worry. If you do miss a couple of slides or the details on the slide, we are going to be emailing these slides, aren't we, John, to all the attendees. So you'll get your hands on these slides and the information within. So, yep, just to start straight away, we've got two key dates I want to concentrate on as I run through the slides. So you'll see these being present in quite a few of the slides. So it's best to understand what those key dates are. So we've got the 1st of January 1949 as the commencement date for the British Nationality Act 1948. And the reason I've chosen this particularly key date in this Nationality Act is to show that there was a different type of British nationality that was available before 1983. That was called Citizenship of the United Kingdom and Colonies. It's a bit of a mouthful, so we do like short-terming it to CUKC. Now, with this nationality, one of the things that's very apparent is it would only pass down in the male line, which is going to be a theme as we go across the slides. It gets replaced on the 1st of January 1983 by the British Nationality Act 1981. So that's the commencement date for the next version of the Act, or the Nationality Act, that creates British citizens as we know them now. So I've got a British passport, and that's exactly the act under which I got it, because, again, this Nationality Act is still in force in the modern day. So a few notes there just to go over. Rights to British citizenship can be passed by descent, by marriage, by birth, and of course the formal action of naturalization or registration. With British nationality, a lot of things do get a little bit complex in the scenario where the UK used to strip off British nationality of certain citizens in the past, especially women married to US men in the past before 1949. So again, I'll run through what effect that has on our modern day clients like yourselves. So jumping on to the next slide there. So we've got citizenship by birth, and again, you'll see these key dates becoming a theme. So those born in the UK before the 1st of January 1983 on the left-hand side. Now, with people born in the UK before 1983, we have a citizenship in United Kingdom and colonies as being the main feature of a British nationality, and it was available to all those born in the UK. So just like the US, it was a just solely principle, which is if you're born in the UK, you get it irrelevant to your parents' nationality. However, the only exemption, which again, a few of our listeners here and a few of our attendees will recognize, is where you have someone born in the UK before the 1st of January 1983 who do not or does not become a citizen in United Kingdom colonies by birth because they were born to someone, say, serving the US Air Force, which did have big bases in the UK. So they would fall under the exception of diplomatic service, whether the father was in diplomatic service or army service for a foreign envoy whilst in the UK. The UK would not give nationality to such a child. Of course, not every scenario is the same, and sometimes you do get children born to US Air Force men and women who will be entitled to British nationality in the modern day. We come across them regularly. Now, we then have this change of overall rules, as I said, from citizenship of United Kingdom colonies to British citizenship on the 1st of January 1983. Children born in the UK after the 1st of January 1983 are only afforded British citizenship if they're born in the UK to a parent who is considered settled or, of course, a British citizen. So no longer given just by birth in the UK. Okay, so that covers citizenship by birth. Now let's look at probably what is the most common scenario here, which is citizenship by descent. So here you have an applicant born out of the UK to a father or mother born in the UK. Now, where the applicant is born out of the UK before 1983, under the original British Nationality Act 1948, as I stated to you earlier, we had gender discrimination being quite a theme in terms of whether you can acquire citizenship through your parent, and you'd only allow citizenship through the father, especially where the child had to be born legitimately. So the UK law did differentiate between legitimate children and legitimate children. That has been fixed, and we'll come to that at a later point. But in terms of citizenship by descent, those born before the 1st of January 1983 would only be able to claim it through the father. So say where the father was born in the UK, as you see the example on the screen, and this will be automatic at the time of the child's birth out of the UK. I would expect such a child now to have a full British passport. Now, what if you are someone that was born before 1983 to a mother born in the UK? Well, you wouldn't have acquired anything automatically at the time of your birth, say perhaps in the USA before 1983. You would have to do what we call a registration in the modern day, and I'll come to that in a few extra slides from now. Now, that change, the whole position changes on the 1st of January 1983. Again, because on that date, the British Nationality Act 1981 replaces the earlier 48 Act and make things gender equal. So you can claim from either parent equally. So if you are someone that's on this webinar and you're born out of the UK, your mother was born in the UK, and you're born after the 1st of January 1983, you say your mother was born in the UK and has maintained British citizenship, then you should be entitled to a British passport now, by descent, of course. You see the date there, if born illegitimately before the 1st of July 2006. Now, as I said, as I pertained to earlier, the UK law did not allow UK nationality to pass by descent if the child is born out of a marriage. That all changed on the 1st of July 2006, where the definition of father was changed to reflect or claims through the biological father, even if the child was born out of a marriage. Of course, that change was in retrospective. So if you're born before the 1st of July 2006 to a father born in the UK, again, you would have to apply under the new rules that combats that type of discrimination now. In other words, a formal registration as a British citizen. So that covers more or less by descent. Adoption, complex area of British nationality law. Child born outside the UK normally relies on biological parents rather than adoptive parents when you're looking at citizenship by descent. Again, the UK, or the UK nationality law, I should say, draws a distinction between children adopted by UK-born citizens, for example, and those who have, of course, biological children born to them out of the UK. There are exceptions, and sometimes we do see claims, even if the child was adopted out of the UK, where adoption has taken place in a Commonwealth country, and before 1983, sometimes it does lead to the child who has been adopted acquiring something called the right of abode for the United Kingdom. That's just permanent residency to come into the UK freely without being subject to any time restrictions. But you would need to prove not just the Commonwealth citizenship, but of course that you were adopted by a UK-born parent. Okay. Now, we also have a remedy in the law that does exist and has existed at least for just before the 1st of January 1983 that allows the UK Home Office, the UK government, to register any child under the age of 18 who have or has been adopted by a country which adoption practices are recognized in a specific order that the UK is part of, and an application is made to register that child as a British citizen. But the criteria to meet is the child would have to be under 18 at the time of the adoption, and adoption with adoptive parents would need to have been born in the UK or British otherwise than by descent. Gender discrimination, again, I'll just touch on that very quickly. It's obviously fixed at the parent level. So in other words, if my mom's born in the UK and I'm born before 1980, that's the parent level. And excitingly enough, for us now in the UK, we also have a new provision that kicked in on the 28th of June 2022 that fixes it at a grandparent level. So through a grandparent born in the UK, even if it's the grandmother, would you believe? So we'll expand on that in the next couple of slides. Citizenship by marriage. So here you have a British husband, British perhaps because his father was born in the UK, British because he was born in the UK. And you being the applicant here were married to him before the 1st of January 1949. And yes, it can be an ex-husband as well for this to work. It doesn't have to be a current husband as well. But rights would flow automatically from that man to the woman as long as the marriage was proved to be before the 1st of January 1949. And of course, that the husband in question was a British citizen, or in other words, at that point would have been a citizen of the United Kingdom colonies or a British subject. British subject was just what British citizenship or British nationals were called before 1949. Now, if you are someone on this webinar, or you know someone on this webinar, the ideal applicant would be a woman born before 1949, because they should need to be married before 1949 to such a man. And in the modern day, such a woman should be able to apply for a British passport. Of course, the comments here, we have to adhere to them. Be careful of foreign country definition, naturalization as a US citizen. That comment is specifically pointed towards what I said earlier, which is the UK had the UK law before 1949, I should say, had a section in there that would automatically strip away British nationality from men and women who were considered naturalized as US citizens or foreign citizens, in other words. So it could be that unlucky situation that by the time you got married to this man before 1949, although he was born in the UK, he naturalized as a US citizen and lost his British nationality. So you'd have to watch out for that. Okay, jumping over to the next slide. Citizenship by double descent, section 12 in bracket 5. Similar to the previous slide, but for the fact that we have an additional generation here who can claim British nationality. So you will see the theme here, which is, again, it talks about the father being British, in this particular instance, by descent through his father, the paternal grandfather. The rights passing from the father to the mom, because the marriage happened before the 1st of January 1949, so the mom would always be British. And in the modern day, an applicant born, say, in the USA between those dates, so after the 31st of December 1948 and before the 1st of January 1983, basically when gender discrimination was rife in British nationality law, such an applicant could now register as a British citizen, would you believe, not through the dad, but through the fact that the mom became British through her marriage before 1949 to a British man, even if the man himself wasn't born in the UK, just British by descent. So again, if you're someone on this webinar who is born between these two dates, not necessarily have to be in the USA, just born between before 1983 and after the 1st of January 1948, and you have an inclination that, yes, my dad was British through his dad born in the UK, and my parents did get married before 1949, this slide would apply to you, and we would be looking at putting an application or submitting an application for your registration as a British citizen based on the new laws that are obviously been set and commenced to combat that gender discrimination you would have faced as you are someone that was born before 1983. Okay, so we got citizenship by double descent. Again, the similar wording, section 7. Without going into it in too much detail, as I said earlier, the British nationality law before 1983 was gender biased. It did not allow women to pass nationality, and I think the UK's first sort of proper attempt to address that gender discrimination was under Section 7 of the earlier British Nationality Act 1948. And that kicked in on the basically 19th of February 1979. It was announced here in Parliament that all British posts abroad or the government here would entertain an application to register any child born to, say, a mother who herself was born in the UK, and specifically children born before 1983, of course. They would register the child under Section 7, which was the UK's only discretionary provision for minor children to be registered in line with their parents' nationality. So in a practical example, you see it on your screen there, which is an applicant born out of the UK, parent also born out of the UK, but the parent is British by descent. And usually the parent here would be the mom, because she couldn't automatically pass it, but she could register this child under Section 7 of the UK law. And I guess the cherry on top is such parents, so the applicant here who was registered under Section 7 would be British otherwise than by descent. In other words, the applicant can automatically pass their nationality to a further generation born out of the UK. So this would not be the applicant as you see on the slide, but their children born out of the UK, just because the applicant themselves are registered in this particular fashion, in this particular section, at that particular time, which would be before 1983. Very difficult to spot these people, and usually they themselves would have a certificate in their armory somewhere in their archives, which would be, smaller than an A4 size, British Nationality Act 1948 written across it in their name, without a section being mentioned under which it had been granted. Usually that would be evidence that it's a Section 7. So do look out for one of the certificates if you have those in your family. Citizenship by double descent remain. So this is an interesting slide, and in fact, remain represents the surname of the lady, a US national who took the UK government to court in 2018 and won. And in fact, she managed to pave the way also to citizenship claims as we know them now through a grandparent born in the UK. So this was a Supreme Court case that actually took place here in Scotland. And her argument was that my mom was prevented, because she was a woman, from being able to register my birth at the British consulate in the USA, which if she was a man, she could have, and I would be a British citizen now. The UK government initially refused, or the Home Office initially refused to grant her nationality on the basis that the law could not make that assumption that the mom would have registered the birth had she been allowed to do so. But the judiciary felt otherwise, and of course the judge decided in our favour. You may ask, what does this mean for me? Well, it's actually as simple as it looks on the screen, of course, which is you do need to prove that you are someone that's born, say, in the USA, being a foreign country. So it needs to be a birth in a foreign country, so a country that's not within the Commonwealth. So as the applicant, you must be born in such a place before 1983, okay? And you can be born before 1949, actually, so you can ignore that bit there. And your mom is British to her father, who was born in the UK, so your mom always has to be a British citizen by descent. The argument here, therefore, would be that had women and men had the same rights, then a woman in this particular slide could have registered the birth of the applicant here at the British consulate within 1 year of its occurrence, which men could. And that would have led to the applicant being a British citizen in the modern day. Again, another route to combat gender discrimination in what was normally allowed down the male line anyway. So again, please come back to us if you're someone, ask questions on this webinar if you can, if you're someone that fits this slide, because I suspect there are a lot of people in the USA that could fit this slide just purely on the basis that they have a British mom who's been British probably most alive to her dad's birth in the UK, and they were born before 1983 in the USA. You could have a claim sitting there to register as a British citizen, and you do not need to come to the UK or live in the UK for the claim to be successful. It can be done on your behalf by the team here. So that's the Remain judgment and how it can be used in a practical case to register as a British citizen through the mom. Okay, so we've got citizenship by discretion, UK-born grandmother. Earlier, I mentioned that the law had been, and by the law I mean the British Nationality Act 1948 specifically, that existed between the 1st of January 1949 and before 1983, was, as I said, gender discriminative, and that addressed that by creating a new section in the law that addresses at a parent level. In other words, if my mom was born in the UK, but what if my grandmother was born in the UK, but not my grandfather? So the moment we've seen in the previous slide, through a court deciding in Mrs. Remain's favour that a maternal grandfather does lead to a claim. But what if it was my maternal grandmother? Well, up until the 28th of June 2022, the answer would have been no. That's not good enough, and you can't register on that basis. But on the 28th of June 2022, we did have the Nationality and Borders Act that you see mentioned on the comments, and specifically Section 4L of this Act comments. Without, again, confusing our listeners here and our viewers, specifically to do with the actual bits of the law, I think in layman terms, what this new law does is it gives an opportunity for any adult to be registered as a British citizen by an application, of course, if they can prove they would be British or would be able to have become British had the law been gender equal. Now, just for a second, if you just consider that there's no sort of limit to how far back, by the sounds of it, you can go. So we went as far back as we could, and we came up with the argument that if the law had been entirely gender equal in the slide you see here, ladies and gentlemen, we know that if you're born in a foreign country before the 1st of January 1988, in this case the USA, your mother was born, say, in the USA, and your maternal grandmother or paternal grandmother, or in fact, even your maternal grandfather, for example, if you're born specifically after 1st of January 1983, the idea would be that if my mom was British at the time of my birth, she could have registered my birth at the British consulate. But my mother couldn't be British because she couldn't claim it from her mother, for example. Or my dad couldn't claim it because he couldn't claim it from his mother, being the applicant's paternal grandmother. So it addresses gender discrimination in two generations, not just for the applicant, but for their parent. And our argument is that the law had been entirely gender equal, then someone in this particular side should be British now and should have had a British passport, from the fact that the birth could have been registered at the consulate and the father or mother should have been British to the relevant grandmother, indeed the maternal grandfather in some situations being born in the UK. Again, let me break it down for you guys. If you are someone that's born in the USA before the 1st of January 1988 and you have a grandparent born in the UK, irrelevant of which of those four grandparents it is, bar the paternal grandfather, of course, it will be worth getting in touch with us and our team, because you could fit into this new section under Section 4L, the current British Nationality Act 1981, and have a claim to register as a British citizen. One thing I also want to touch on, just in case it's not on the next slide, which I'm not too sure if we actually did put on, because it's quite a recent development, again, quite exciting, is that anyone that's registered under this section is considered a British citizen at the moment, otherwise than by descent. That means any children born to them after they've been registered under this section should be British citizens by descent. So if you're someone that's about to register under this section and you're going to have a child, say, 9 or 10 months from now, that child, even if the child's born out of the UK, the laws remain the way they are now, then the child will be a British citizen by descent, even if they're born out of the UK. So worth doing, if indeed that becomes a situation for yourself. I will also add that at the moment they're also entertaining applications for discretionary registrations for children who are under 18 at the moment, or the parent has subsequently become British through this new law. So in other words, if I become British now, but I already have children under 18, and if they're under 18 when I become a British citizen under this new Section 4L, then I can go ahead at the moment and register my children before their 18th birthday, just solely on the basis that I became British through Section 4L. So again, even if you already have children under 18, they may not have missed an opportunity here. It's worth getting in touch for that reason in itself. Because citizenship by double descent, Section 3.2, now we're going away from claims opportunities for adults to become British citizens, which was more or less what was covered so far. This section that you see in front of you on this slide specifically points out to children under 18. So under 18 now and under 18 at the time of the potential application under Section 3.2 of the current British Nationality Act 1981. This provision was or is specifically pointed towards British citizens by descent who have children born out of the UK. Because one thing to remember for the entire length of this webinar, gentlemen and ladies, is that British citizens by descent cannot normally automatically pass on their citizenship to a further generation born out of the UK. So if you are a parent listening in on this, you are a British citizen because your dad or mom was born in the UK. You always had a British passport, but you now have children born to you, say in the USA, and they're under 18. And you can prove that you yourself at some point in the past, before the children were born, spent 3 years in the UK, living here continuously, with no more than 270 days out in those 3 years, then we can register your children as British citizens under Section 3.2 without any future UK residence required for yourself or the children. In other words, the application can be done whilst the family is there in the USA. Would you believe? So it's just to provide a route for that generation to claim their parents' nationality, even though the middle generation, being the parent generation here you see on your screen, is also born out of the UK. But it does require the parent to prove that 3 years of UK residency before their children were born, and the child to be under 18 at the time of the application, of course. So that potentially could appeal to some of our listeners today. The right to abort. So we touched on that earlier through adoption, but you can also get it through marriage. So a woman who's a Commonwealth citizen, and you can see the examples on the screen, I'll read them out, marries a British man before 1983, maintains a Commonwealth citizenship throughout, automatically and is entitled to what they call the right to abort for the United Kingdom. Again, this is not British nationality, number one. Number two, it's actually an endorsement that will be, if granted, put or stuck onto the US passport, Canadian passport, for example, it would be in most cases. And it does entitle the holder to unrestricted access to the UK without any time restrictions. So you can enter the UK as and when you please. You don't really lose it unless you renounce your Commonwealth citizenship, you lose it. And you can live here as long as you want without renewing it as such. If you did live in the UK on the right to abort for 5 full years, and with other criteria being met, you can naturalize as a British citizen. Practical terms, this is specifically a route just for women who are married to British men before 1983, but in more specific details, a Commonwealth citizen. Dual nationality, just to touch on it ever so quickly, I often get asked about whether I can have 2 passports, 3 passports. How does that work? The UK allow dual nationality? And the answer is simply yes. The UK does allow someone to have dual nationality, and so does the USA, and so does Ireland, which my colleague will cover. So it shouldn't be that you base a decision around not becoming a British citizen because you're nervous about the UK stripping, the US stripping you of your US nationality, or the UK not liking that you're a US national. That's not the case. So I'll hand it over to John. I hope that's made good sense. Sorry, I rushed through it perhaps a little bit too quickly, but I am trying to create a larger Q&A session at the end of this, so you can ask all your questions. But I'll hand the slides over to my colleague John, who will run through the UK immigration options. Thank you.
Thank you, Michelle. That was very informative. I can see that quite a couple of questions have come through, and I'll make this brief so we can get through to those. As Michelle mentioned, if you know right away that you don't have a claim to British nationality, or you don't necessarily want to take up citizenship right now and want to relocate to the UK, there are options for you. The ancestry visa is one option where if you have a UK-born grandparent, you can live and work in the UK for 5 years. There are very little requirements for that visa, and it's one of the only visas that are issued for a full 5 years at the moment. The spousal visa, if you are married to a British national and would like to relocate to the UK with your children under the age of 18, you can apply for the spousal visa. The main requirements there are a financial requirement. You can meet it in various ways, but the shortened version is through cash savings. You must hold cash savings of £62,500, or you must be earning the equivalent of £18,600 per annum. The skilled worker visa, that is if there is a company in the UK that is willing to sponsor you, you no longer need to do a resident labour market test, and they have lowered the threshold for minimum earnings. So the skilled worker visa is a good option if you do not have links by ancestry. That visa is issued for 2.5 years with an extension, and which can take you to the 5 years, and all three of these visa categories can take you through to permanent residency or indefinite leave to remain, and you can naturalize afterwards as well. We do Irish and EU nationality. If you have links to any of the member states, Irish is quite straightforward. You can, if your parents are born in Ireland, they can pass it down. If you have skipped a generation and you have a grandparent born in Northern Ireland, the Republic of Ireland, sorry, you can get Irish nationality, and that is through a foreign birth registration. Those applications do take 2 years. Adoption is a consideration when doing the foreign birth registration. If you were adopted, the adoption needs to be registered in Ireland for it to work, but it is possible. I think I'll leave it there, and we'll move on to the Q&A part of the webinar. Michelle, if you're all right, I will start with Carlos. I'll give you Carlos's details that he listed on the chat. Carlos was born in November in 1956 in Mexico City. His father was born in Mexico but registered at the embassy as a British national. His maternal grandparents were born in the UK. And that is the information that I have for Carlos.
Well, thank you, Carlos, if you're still on the webinar, which I hope you are. That's, so if I've got that right, John, 1956 in Mexico, date of birth, or year of birth, rather.
Correct.
Yep. And the father was born in Mexico, but his parents were born in the UK.
Correct.
Yeah. So chances are that Carlos may have a claim to register as a British citizen on the assumption that it could be that the parents got married before 1949, which will represent my slide number 304 under section 205. If not, and the parents got married just after 1st of January 1949, then I'm afraid it's a no from what I can see, because Carlos's father would be by descent at best. Of course, we can look at other options at a later point if there are any sort of complexities around illegitimacy and so on.
Okay, so we started off with a maybe. We'll move on to E.A. Murray. He was born in April 1964 in the US. His mother and father were also born in the US, but his maternal grandmother was born in the UK.
Maternal grandmother.
Maternal grandmother.
Yeah, so exciting for Mr. Murray. I would say so, because he would, well, he does fall under the Romain judgment.
Sorry, E.A. Murray is a female, not a he. Apologies.
Beg your pardon. Beg your pardon. Mrs. Yeah, so that would be a Romain-based case or a Romain judgment-based case. So that would be a very similar sort of physical attributes to Mrs. Romain, because she was born in the USA before 83. Her mom was British by descent, her maternal grandfather born in the UK. So I would say very likely for a registration as a British citizen now.
All right. What I will do is I will post a link to our online assessment, which we would ask you to complete, whether you get a yes, no, or maybe. We will ask you for some of this information we have asked. If you can complete that, it is a free assessment, and then we can just confirm all the details, and we'll send you an answer over email just to confirm what we said on here. So moving on to Elizabeth. Elizabeth was born in February in 1944 in the US. Her parents were born in the US, and maternal and paternal grandparents born in England. So her mother's parents were born in England, and her father's parents were born in Canada.
Father's parents born in Canada.
Yes.
The paternal grandparents born in Canada. Maternal grandparents both born in the UK.
Yes, sorry, Elizabeth was actually born in Canada.
Sure. Okay. Yes, I'm afraid the Canadian birth is the issue here, I'm afraid, Elizabeth, because if you are born in a foreign country, which would have been the USA in this particular set of scenarios we're facing right now, to a maternal grandfather or grandmother born in the UK, then the argument would be that your mom should have had the opportunity to register your birth that took place in a foreign country, hence leading to citizenship in the modern day. But being born in Canada, obviously, is not a foreign country at that point. And so that particular route won't work. There could be other routes, but not on those facts, I'm afraid.
Okay. Apologies if I get the pronunciation wrong, but Gulsha has put in a question. Born in April 1987, born in India. Father born in Tanzania in 1956. He had a UK passport, which he gave up in the 1980s. I'm not sure if it was renounced or he let it lapse, but it just says he gave up citizenship in the 80s, and he became an Indian citizen.
Right.
Her mother and all her mother's grandparents born in India.
Right. Question. Yeah. Thank you for posing that question. So that's similar background to mine. I come from Kenya with Indian ancestry, as you can probably tell by my surname. Yeah, absolutely. It was a common theme that the East African Indians, especially men, would require work permits, otherwise would renounce their UK nationality in order to work in places like Kenya or Tanzania, because both places did not allow dual nationality, while Kenya, now introducing it to Tanzania, still doesn't allow it. I do believe that their father renounced his British nationality, and if that happened before you were born, which is likely from what you just told us, then, sorry, John.
It was before. It was before.
It was before, yes. Then in that case, I would be looking at carrying out an investigation to see whether that pronunciation can be declared null and void. Perhaps he wasn't registered properly, and if so, can that lead to a claim for you? So I'm afraid the answer is a maybe, because I'm not too sure what the actual ramifications of that renunciation are. But if indeed it was registered validly and it's effective, then of course there's nothing that we can do in modern day, I'm afraid, for you.
Okay. So moving on to Amanda. Amanda was born in December 1985 in the US. Her mother was born in the US, and her father was born in England, in the UK. Paternal grandparents were born in the UK, and maternal grandparents both US. And parents were never married.
Sure. Father born in the UK. Does Amanda mention when her dad was born in the UK in terms of the year of birth?
She hasn't given a year of birth at the moment.
Not to worry. That's absolutely
Amanda,
fine.
if you are online, if you could post that year of birth, 1963.
1960. Yeah, I just saw that come up, John. Excellent. Yeah. So with all things being equal, and really by that I mean, Amanda, that your father's parents were not considered diplomats whilst your dad was born in the UK, which I suspect not, because they themselves were born in the UK, your paternal grandparents. Then your father was British otherwise by descent at the time of your birth. Of course, being born out of a marriage disqualifies him from being the father or the parent for the purpose of the British nationality law. However, the good news is that as long as we can prove a biological link to your dad, and there are various ways of doing that even now, we can register you as a British citizen. So in other words, there is a section in the law now that now deals with the obviously unfair situation where children born out of a marriage are not entitled to their father's nationality. So you do, in my opinion, have a claim, of course. That's in theory, and in practical terms, you would need to sit down and work on a document list that works.
Okay, thank you. Then the next
Yeah.
question is from Glenn. Glenn was born in the UK in 1980. His parents and grandparents were all born in the UK as well. He has 2 children with a wife born in the US. He'd like to know if they are eligible, and then he does have a stepchild who is American. Do they have a chance?
Sure. I think, Glenn, fairly straightforward. You probably already know that the 2 children, your biological children born to you in the USA, are entitled to British passports, and I'm basing that on the assumption that you acquired your citizenship by your birth in the UK in the 1980. I believe that was, John, wasn't it?
Correct.
Glenn's birth. Yeah. So your children should be able to apply for their first British passports, something that John's team can actually help with. And once the children get those British passports, it would be as simple as renewing them as and when you need to. And they'll be British citizens by descent. Now, regarding the stepchild, not entirely straightforward, of course, and you probably guess that, because if that's not your biological child, then you can't automatically pass on any British nationality rights to this child. Having said that, if the child is under 18, there could be routes that we could discuss in a separate conversation, of course, not for this platform to design a route for the child to get citizenship, but it would require UK residency of a certain amount from that child and family, of course. So there is that. Now, regarding your wife, nothing automatic, I'm afraid. It would be an immigration route that John covered in one of his slides that would entitle her to UK residency with a view of naturalizing as a British citizen, having spent X amount of time living here, of course, with yourself.
Right. Okay, so moving on to Brioni. Brioni was born in the US in July 1969. Her mother was born in the UK in 1936. The maternal grandparents were born in the UK. Her father and his parents were all born in the US. Brioni does mention that the parents became US citizens in the 1940s.
Right. Okay. Yeah, that is a slight pause of concern that I had there, Brioni, because of course, if your mom, although born in the UK, so clearly British by birth in the UK, and but at the point that she became a US citizen, if she's deemed as a naturalized US citizen, which is not quite, it's not as straightforward as just saying yes or no, but we'd have to actually find out exactly how she became a US citizen. Was it because she was included in her parents' naturalization, your grandparents? Did she have her own one, which wouldn't be right because she would be a minor at that point. So I would have to look at that, but I would be aiming for her not to be considered a naturalized US citizen, or parents, and where I can do that, I would then be arguing that your mom has been British all her life for that reason, and you should be allowed to register as a British citizen through your mom's nationality, and obviously where she was born. But I don't think I feel confident in saying yes, it's likely. We probably need to look at that method of acquisition that your mother used or her parents for becoming a US citizen.
Okay. We will do Janine and then Lauren. So for Janine, Janine was born in Switzerland in April 1957. Janine's mother was born in the UK. Her father was also born in Switzerland. Janine's maternal grandmother was born in the UK. And then I see her maternal both sets were born in the UK, and then paternal grandparents were all born in Switzerland.
So the father's side seems to be Switzerland,
Swiss,
like Janine's. Yep. And the mom's side's the British
all
side,
UK.
born in the UK. Yeah. So as long as, again, it's similar to Brianni, and as long as we didn't have the mom losing her UK nationality, which she clearly acquired by birth, then Janine would have what I would think a very straightforward claim to register as a British citizen in the modern day without any UK residence again. So that's probably good news for Janine.
Great. All right, then we got Lauren, born in July 1966 in the US. Lauren's mother and father were both born in the US. Lauren's paternal grandfather was born in the UK, and the paternal grandmother was born in Austria-Hungary
Interesting.
area. Yeah.
And I guess no details on the mom's parents there or US. So this should be Lauren's mother's
US,
parents.
correct. Both US.
Both US.
And then,
so the only UK connection was the paternal grandfather was born in the UK.
Correct. And then Lauren's parents were married after 1949.
Yes, so I was just about to ask. Yeah, not good news for Lauren. I'm afraid, Lauren, sorry. Only because your dad would have been by descent and always had the opportunity to register your birth at the British consulate in the USA. So there is no discrimination there to argue under the new law, at the very least. And considering that your maternal grandfather wasn't born in the UK, I obviously can't use the Remain Supreme Court judgment to argue that your mother should have been entitled to register your birth, even if your dad failed to do so. So I'm afraid it's looking negative from where I am, Janine. Lauren.
Yeah, Lauren. Okay. Then we're moving on to Sophia. Sophia is a Kenyan citizen. Let's see. Her mother was British by descent. Through her father was born in the UK. So Sophia's maternal grandfather was born in the UK.
Mm-hmm.
Sophia's father was Kenyan, and that line is all Kenyan. So the only link is Lauren's maternal grandfather.
Right, and Sophia is Kenyan, did you say?
Correct.
She's a Kenyan citizen. And what's her date of birth? Do we know? Or year of birth?
I don't see a year of birth.
Okay.
Sophia, if you are online, if you can just give us that date.
Right, yes. So if Sophia's only UK connection, John.
1984.
Sorry, go on.
1984.
1984. Okay, just after the 1st of January 83 cutoff. Yeah, I thought that might be the case. So the mom's by descent. And there's, if Sophia, if you're on there still, was your maternal grandfather working for the UK government at the time your mom was born, perhaps?
No response.
Yes, he was.
He was.
Yeah, yes, it was, which is usually what I find. So, Sophia, we could have a scenario here where your mom's actually British, otherwise by descent through her father's crown service. And if that's the case, and we can prove that, of course, which I'll be more than happy to explore with you, then you could already be a British citizen as we speak now and be entitled to a British passport through your mom. On your dad's side, I understand he's born in Kenya, perhaps before independence, but I would really have to sit down with you and understand what happens to his UK nationality. Does he retain it when Kenya becomes independent, or does he lose it? And there's a formula to apply to ascertain that. So I can't be too certain on whether a claim to your dad exists, but we can explore it. But a claim to your mom seems likely based on crown service. Worth exploring, I would say, Sophia.
Michelle, I don't know if you have
Sure,
Gulsha's details with you there, but she has
I do
asked,
indeed. Yeah.
can she apply for an ancestry visa? I'm just having a look again.
Mm, yes, she was born in India in 1987, I believe, and we know that her father gave up citizenship. Kausha, to apply for a UK ancestry visa, and John, I think you're probably better off covering it, but you do need
UK-born
a UK,
grandparent.
right?
I
Yes.
couldn't see where the grandparents were born there. Sorry. Yeah. Okay. So, Gulsha, the answer is unfortunately no. Then we're moving on to Ron. Ron is asking on behalf of his wife Tina, who was born in the US in October 1966. Tina's parents were born in Uganda. So her maternal grandparents were born in India and lived in London from 69 to 76. Is there anything there? There are no other links to any other family members, so I assume that's the only links to the UK.
Yeah. So Tina herself is born where did you
The
say?
US,
Sorry, I missed that part. The
California.
US.
Yep.
Okay, and that's before 1983, I assume.
1966.
66. Right. And it's her grandparents who were born in Uganda before independence, but that's her maternal grandparents because her
Correct.
paternal grandparents were born in India but resided in the UK.
It doesn't say where the paternal grandparents are. It's just maternal grandparents
There was something to do with living in the UK.
in London.
Was it the maternal?
The maternal
Yeah,
grandparents,
was it? The ones
1969
from Uganda.
to
But that
1976.
explains it because of the expulsion of Asians from Uganda at that point. So that makes sense. Yeah, just based on that information, I'm afraid I'm not. I can't see a claim only because it's the grandparents living in the UK, not her parents. If a claim would exist, it would have to be through Tina's relevant dad or mom. In this particular case, we could have a potential positive scenario for Tina where her mom had lived in the UK as a minor with her parents, who are the maternal grandparents, escaping Uganda. And if Tina's mom had picked up UK nationality before Tina's birth in the USA, then of course Tina could have a claim to register as a British citizen now to a British mom. But we would have to, obviously, we'd have to know a lot more to ascertain that, John.
Okay, I have a question from Peter.
Okay.
Peter says his grandparents were born in the UK.
Okay.
His parents were born in Canada in 1929, and Peter was born in Canada as well. He has Canadian, US, and Irish citizenship. Is there provision for
Right.
the UK?
If the assumption is if Peter's father's parents were born in the UK, and if Peter's parents, I'm not too sure when their marriage date is, but if it's before 1949, then yes, Peter could have a claim to register as a British citizen. But if not, and if it's their maternal grandparents born in the UK, with Peter's parents born in Canada and Peter himself, then I'm afraid not. There wouldn't be any automatic acquisition route for British citizenship, even if the parents were married before 1949. So that's if the maternal grandfather or grandmother were born in the UK.
It was the maternal line. Peter did post something a little bit later down.
Okay, fair enough. Fair enough. Well, Peter, sorry, it would have to be a no, based on the fact that your mom is obviously British by descent and has been, but wouldn't have had the ability to pass it on to you even if the law had been gender equal. So we can't argue that you've been discriminated against in terms of the new law.
Okay. I'm moving on to Marsha. Marsha was born in March 1974 in the US.
Right.
Her father was born in the US and her mother in Peru. The maternal grandparents, it is Peru, and the paternal grandparents are the US.
Right.
There are great-grandparents in Ireland,
Mm.
and she seems to think that it was part of the UK at that point.
Yes, Marsha. I mean, you're entirely correct. So before 1922, the sort of Irish Free State was formed. It was all Great Britain and Ireland, both parts of Ireland at that point. But effectively, what happened was that British citizenship that was acquired through birth in what is now the Republic of Ireland, perhaps, um, gets taken away when Ireland was, well, Northern and Southern Ireland split happened. And as modern times progressed, that those British nationality claims were basically taken care of by the new Irish Republic state, and they don't exist in the modern day. So at best, it will pass one generation, but not four or three, and definitely wouldn't pass on to you, I'm afraid, in terms of just the British nationality side of things, of course. Whether you're entitled to Irish citizenship remains to be ascertained.
Okay, I have a question here from Phyllis. It's slightly broken up, but Phyllis was
Okay.
born in the Bahamas in August 1974. Her father is a UK citizen. She doesn't say how. Her grandfather and grandmother are also UK citizens through her father's line.
Right. Does she talk about any UK residency for her parents, perhaps in the 60s and 70s, John? Or if she's on there, Phyllis, if you're on there, do your parents ever live in the UK? And if so, how long for? Because that would be quite good.
There's no detail at the moment. Maybe
No,
we
just
can.
a moment. You're going to give her a sec.
Sure. There we go.
There you go. My father lived in the UK. Yeah. Do you know, Phyllis, when it was? Was it before you were born or after you were born, and so on? Could you provide us any further details there? Just waiting on Phyllis, guys. Nothing there, I'm afraid, John.
Did you
so
want
Phyllis, if you're still, there you go. Father date of birth,
1920.
1920. Okay, not quite what I was after, Phyllis, but that's fine. In summary, Phyllis, you're born after independence in Bahamas. Perhaps your father has picked up UK nationality just by virtue of moving around in UK residence before your birth, which would be what was required or what is required for you to have a claim now. If not, then it's probably unlikely that you do have a claim. So it's worth getting in touch if you have any information on how and when your father became a British citizen, of course.
Okay, we'll answer a couple more questions. Then we'll have to wrap it up. So we'll go for Marie,
Sure.
born in the US in 1955. Her parents were both born in the US. Her maternal grandmother was born in the US, and her paternal grandfather was born in Wales, the UK.
Okay. Any word on her maternal grandparents, where they were born, John?
Just it
Mary's.
says maternal grandmother US and
Okay.
paternal grandfather UK. There's no other details about the other two.
Okay. All right. Well, I'm afraid, Mary, if it's only your paternal grandfather born in UK, then on that basis, unless your parents were married before 1949, you wouldn't have a claim to British citizenship. Now, if your maternal grandfather was also born in the UK, your mother's father, then you do have a claim under the Remain judgment, irrelevant if your father was British or not through his own father's birth in the UK. Now, if parents were married after the 1st of January 1949, and again, it's only your paternal grandfather that was born in the UK, then I'm afraid the answer will still be no.
Okay. I have a question from Doralita, also born in the Bahamas in March 1980.
Right.
Both her parents were born in the Turks Islands. Maternal grandparents born there as well.
Okay.
All her grandparents. Paternal great-great-grandfather Scotland.
Paternal great-grandfather, did you say? Right. Okay. And can you just reconfirm where her parents were born? Sorry, was it Turks and Caicos Islands?
Correct. Correct.
There was, thanks for posing that question. Yeah. And the Turks and Caicos Islands, obviously UK colonies in the past, and in fact are still part of the UK now, and they're considered British overseas territories, as you probably know. And one of the new changes in the law, Doralita, and I hope I'm pronouncing that right, is that for the first time, the UK have acknowledged that it would be unfair to provide British nationality solutions for those who would be British citizens had the parents been married, but not those who would have been British overseas territory citizens had the parents been married. So, in other words, you know, I do think you have a claim to your dad, who was born in a British overseas territory. You would have to prove a biological link, and it would be, in fact, a registration. It's actually two registrations that are done simultaneously under the new laws that kicked in. One's as a British overseas territories, and then we change you to a full British citizen. Because, of course, British overseas territory citizenship now can be exchanged for British citizenship, as you know it. So I do think you have a good claim here if you can prove your biological link, of course, to your dad. So that's good news for you.
Okay, we will go to one final question from Norman. Norman was born in March 1952 in the US. Both of his parents were born in the US. The maternal grandparents born in US. Paternal paternal grandmother was born in the UK. That's the link in 1911.
Right.
So paternal grandmother, and her father naturalized a US citizen in 1921.
There I was getting a little bit excited there because I thought that's it. That's the lady we want. Remind me of the gentleman's name again, John?
It's Norman.
Norman. I do think it's worth having a conversation and engaging us, because I would really like to see whether that naturalization for your great grandparent removed any UK nationality that your paternal grandmother had. I doubt that happened, and which is a good thing. And if it didn't happen, then we do have a case under the new Section 4L to register you as a British citizen. Of course, an argument would be based on gender discrimination. In other words, if the law was entirely gender equal, your dad would have been British through his mother's birth in UK and could have registered your birth at the British consulate, which would in turn mean you should have been a British citizen all your life. So that's the argument we would use with the relevant laws supporting it. But exciting if we can just cover that one basis of the naturalization. So you seem to obviously have the paperwork for it if you're quite certain they naturalize your great grandfather on the paternal side. So it will be worth sitting down and exploring what does that mean for your grandmother. But it's looking likely.
Okay, Michelle, I'll just have one correction for Tina.
Sure.
So Ron's just
okay. Yep.
Tina was born
in
Uganda.
Yeah, USA in 66.
No, well, sorry.
Oh, Uganda, right?
Uganda,
Okay.
1966.
Right.
Living in the US now.
Fair enough. Okay.
All four grandparents and parents born in India. So I don't know if that changes anything.
Yes. Her place of birth, that wouldn't change.
Uganda, 1966.
Yeah. Her place of birth being Uganda, not the USA, would not change the outcome of what I said earlier. I don't think that matters because Uganda was independent at that point from the UK in 66. So that's number one. Number two, with all four grandparents being born in India and none of them in Uganda, what that does mean is the father probably held on to his British nationality because it did not become an automatic, or parents did not become automatic citizens of Uganda when Uganda became independent before Tina was born. So there may be a chance that she is born to parents who are British just because of that Ugandan connection. Now, I'm not too sure exactly where, if they obviously moved to the UK, if they picked up another UK nationality, but it does seem there's something worth exploring there.
Yep. Okay, so he does say that it appears that the father was a British subject. They lived in the UK from 1969 to 1977. So I think, Ron, if you're still on, we do have the assessment, and you do have our contact details. For those of you,
Yes.
if we didn't get the questions entirely correct, or you have any further questions, our details are below, citizenship@sableinternational.com. You can
Yep.
call us, and or I have posted the link to our online assessment. If you go in there, like I said, it's free. It's quite quick to complete. If you have the dates and places of birth, it'll just allow us to look at it as a whole picture, and view the family tree in a nice format, and then we will give you the answer by email, and then we are happy to call you once we have that answer as well. So thank you very much for joining us on our webinar. We had some great questions there, and seems like some positive ones. Please do get in touch. Michelle, thank you very much.
John, thank you very much, and thank you all for joining us.
Goodbye.
Bye now. Bye.